The first is Badose v. Garland out of the First Circuit on September 20th, which is a bit of a unique case, but it made me chuckle. It's about motions to remand. And don't get me wrong, the procedural history of this case is such that it would be very hard to get this ruling again. But you might not need to get this ruling again now that the First Circuit has issued it precedentially, and it is this. You've got this guy, Mr. Badose, is from the Democratic Republic of Congo, loses an asylum case deemed not credible, and while on appeal to the BIA, marries a U.S. citizen, seeks to remand his case back to the immigration judge so he can pursue adjustment of status. He has a lawful entry, I believe, as a student. Committed a lot of things that led to that adverse cred finding, but nevertheless wanted a chance to pursue his green card. And the BIA appeal is still pending. It's a motion to remand. It's not a motion to reopen. DHS did not oppose the motion to reopen. They didn't file anything, as so often the motion to remand, not the motion to reopen. DHS didn't file anything, which is technically a non-opposition. That happens all the time, okay?
Yeah.
But the BIA denied it anyway, and they issued, you were found not credible, and it seems they might have thrown some shade on the validity of his marriage, the fact that they got married during the BIA appeal, all of that. And the First Circuit reversed. And don't get me wrong, I talk about the procedural history. It seems that Oil, the first, waived the argument that the BIA is supposed to, grant these unopposed motions to remand. It seems Oil waived it, and they wouldn't waive that again.
Mm-hmm.
But Mr. Badose submitted 15 cases, unpublished BIA decisions, or 20 of them over 15 years. It's not even that many, to be honest with you, where the BIA is granting these unopposed motions to remand. And Mr. Badose described that as the BIA then, in denying his, having, quote, inexplicably departed from a settled course of routinely granting unopposed remand requests so that petitioners can pursue adjustment of status, end quote. Oil didn't really combat that pretty wild assertion that it is a settled practice that the BIA will always remand. I mean, I'm not at the BIA. I'm not quite sure that's the case, but now it is in the First Circuit, because they found it arbitrary and capricious that the BIA would go against this settled practice and not just remand it to let Mr. Badose pursue it, where DHS had not opposed the motion to remand, which again happens all the time. So think about Badose v. Garland now. By the way, I've gotten some emails about this since it came out. I did it on the podcast. When I file these motions, I'll often then, wait the 10, 13, 20 days, whatever it is, plus some days in BIA or immigration court, and I'll often file a motion to deem motion unopposed. Because under the practice manual for the IJ and BIA, and under the regulations, after a certain amount of time passes, the IJ or the BIA has the authority to deem any motion unopposed if no response is received, just like in any court. Doesn't mean you're going to win, but I will follow those motions. And you best believe I'll probably be citing to Badose v. Garland from now on, talking about how it's a settled course that the BIA should remand under those circumstances where DHS doesn't oppose. Not only that, the First Circuit found that there was error in the BIA to really touch the validity of this marriage at all, given that is fact-finding, and so you really just got to remand it for the guy to get his day in